Hello, hello. Suzanne Dibble here, data protection law expert, doing a live Q&A for people who have bought the GDPR pack. Welcome to this beautiful sunny Monday. So we'll just see if anybody's going to join. I've not advertised this today, so we'll see how many people join us. If we've got 10 minutes of questions, that's great. If we've got half an hour of questions, that's great. If we've got an hour of questions, that's great. And I normally say if we've got 2 hours of questions, that's great. But today it isn't great because my littlest has her sports day starting at 2 o'clock today. And it was rescheduled from last week because it was a beautiful week apart from the 2 hours that their sports day was scheduled for when it absolutely chucked it down. So today is the repeat of that, and touch wood, so far it's looking a lovely day. So I've got to nip off at just before 2 for that, but otherwise I'm here to answer your questions for the next at least 45 minutes if we have that many questions. So let me just, I don't have my iPad today, so I'm going to look at your questions on the screen. So hi Ginny, hi Shell. Question from Ginny. I send personal data, sometimes sensitive data, in the form of client recordings to rev.com for transcription. This is outside of the EEA as it's in the US, and I expect they farm out the work to people from various countries. I have a confidentiality agreement with them, but this predates GDPR and isn't a processor agreement. Having watched your Module 2 video and looked at the documents, I'm still unsure as to how to combine the data transfer outside the EEA clauses with the main agreement so I can send it to them for signing. I've emailed them to ask if they'll sign it, but have received no reply. Can you clarify? By the way, I'm happy to gain explicit consent from each client in advance of doing this. In fact, I do that anyway because of the sensitive data. Maybe that means I don't need the processor agreement and can rely on consent. Ginny, I'm guessing that you already had that question ready to go and pasted that in as soon as I came on. Top marks to you for being so prepared. Right, okay, so yes, you will need a processor terms with rev.com, and if they haven't already amended their own terms to cover that, then you would need to send them a processor agreement. That is completely separate to the location of the processor. So every processor, whether they're in the UK, in Europe, wherever, needs processor terms if they are processing personal data under your instructions. If that is outside of the EEA, then you need to look to the rules on that, and that's where there's almost like a tiered approach to the safeguards that you need to have in place. So the first question you ask yourself, and Ginny, if you haven't already looked at the transfer of data checklist, I think that's in Module 2.2, then have a look at that. But the first question is the processor that you're sending the data to in the country that has had an adequacy finding from the EU, which is effectively where they've said that country's data protection laws are adequate and you don't need an extra level of protection. So those countries are places like New Zealand, Canada, Switzerland, and then some fairly random ones like the Faroe Islands and Uruguay. If you search in the group for adequacy finding, you'll find there's 11 or 12 countries. Now, saying that, those adequacy findings are not set in stone, and they can be reviewed at any point. So those are the ones that are current at the moment, but you do need to keep a bit of an eye on it because countries can lose an adequacy finding, and similarly, new countries can gain adequacy findings. So if I hear anything about that, I'll be posting about that in the group. But at the moment, if you search in the group for what are those countries, and I think also there is in one of the checklists, probably the data transfer checklist, it's got the list of those 11 or 12 countries. And so if you're sending it to the personal data to a processor who's not within those countries that have had an adequacy finding, then the next question you ask yourself is, well, if they're in the US, are they part of the Privacy Shield? Because although the Privacy Shield isn't it doesn't cover the whole of the US, to the extent that companies are signed up to the Privacy Shield, then that is the equivalent of their adequacy finding. So some of the big processors that we use, like MailChimp and Aweber, are signed up to the Privacy Shield. And that means, again, that if they're part of the Privacy Shield, then you can just, without any further documents or anything else, you can transfer that data to that company. If they're not part of the Privacy Shield, and remember that it's only countries in the US that have that capability of being within the Privacy Shield. So say you're dealing with a processor who's not in the Privacy Shield in the US, or is outside of the EEA and not in the US, then you need to look at the next level of protection. And in terms of contractual measures that you can put in place, that's where you're looking at the standard contractual clauses. That's a standalone document, okay, and that is in the module 2 of the pack. So the best thing really to do is to have that as a standalone document. So you'd have your processor terms or your processor agreement, and your standard contractual clauses. Now, if for whatever reason the processor doesn't want to enter into those standard contractual clauses, or they're not appropriate, so for example, if you've got a US data controller transferring data to a US processor, then that still is an international data transfer, and the standard contractual clauses don't actually provide for transfers from a data controller who is outside of the EEA, because when they were put into effect, GDPR wasn't in force, and GDPR, the data protection regulations at that point, didn't extend to people outside of the EEA, i.e., people in the US weren't within the territorial scope, so they didn't anticipate that there would be a US data controller. So in those circumstances, you then look to the derogations, and consent is just one of those derogations. Let me just find the relevant bit. Sorry, the other thing that we never really talk about as much as we should is binding corporate rules, and some companies where they are multinationals will have binding corporate rules in place, and they will be transferring data under those binding corporate rules. If you're a processor, or you're a data controller looking to send to a processor outside of the EEA, then unless you are a very large multinational, BCRs or binding corporate rules aren't going to be appropriate, because they take about 18 months and you have to negotiate them with the data protection authorities. So they're really only appropriate for, as I say, big multinationals where you've got lots and lots of data going back and forth. So the derogations. So the first one is that the data subject has explicitly consented after having been informed of the possible risks of such transfers. The second one is that the transfer is necessary for the performance of a contract between the data subject and the controller, or the implementation of pre-contractual measures taken at the data subject's request. So, Ginny, if the transcription is necessary for the performance of a contract between you and your client, then arguably that would satisfy that derogation, and you wouldn't need explicit consent for that transfer. Okay. The third one is that the transfer is necessary for the conclusion or performance of a contract concluded in the interest of the data subject between the controller and another natural or legal person. Okay, so that's not where it's necessary for the performance of a contract between the data subject and the controller, but it's in the interests of the data subject, and it's between the controller and a third party. The fourth one is that the transfer is necessary for important reasons of public interest. The next is the transfer is necessary for the establishment, exercise or defence of legal claims. The sixth is it's necessary to protect the vital interests of the data subject. And the seventh is it's made from a register which, according to union or member state law, is intended to provide information to the public. So the three that are likely to be relevant for you, Ginny, are those first three. And it's, certainly the second one, if it's necessary. So you'd have to ask yourself, is it necessary for the performance of the contract between you and the data subject? Then that is a derogation that can apply. In my view, I know that you're dealing with, you're not dealing with hundreds of people here. I would, be upfront about it and say that's what you're doing, and get consent. But saying that, I think, if it is necessary, only you can answer that. But if it's necessary, then you can rely on that derogation. Okay, so I hope that's cleared that up, Ginny. And thanks for that question. Okay, Robert says, hi Suzanne, we're working out whether we need a separate processor agreement or to just include the wording on our terms, and we came across the section at the end of both the DPA and the clauses document which we are confused by. It's the personal data processing purposes and details. We're not sure how to fill out this section. For example, what is subject matter of processing and what are data subject types? Okay, is this in the schedules at the end of the processor agreement, Robert? If it is, you'll see that in the version that's in the pack at the moment, there's examples in there. So maybe take a look at those examples and then let me know if you've got any questions on that. But the one that is in the pack at the moment, which it's been updated to include examples because a lot of people were asking exactly the same question. So if you haven't looked at that one, then go and look at it. If you have, then type a comment in the comments box and we can talk that through. But that should be, hopefully those examples are enough to help you with that. Jeanette says, wondered if you had any more thoughts as to whether the privacy policy should be a pinned post on Facebook, or would it be okay to just put a link in the About section? Appreciate this is a fluid situation given the recent German case. Yes. So for those of you who don't know about the recent German case, there was I did a video on it recently, and this is where a Facebook page administrator has been, there's been a ruling, an ECJ ruling as part of an ongoing case in Germany that Facebook page administrators have certain responsibilities that we didn't think they had. So if you don't know about that, go and watch that video. But whether the privacy policy should be a pinned post on Facebook, I mean, in my view, there's no harm in sticking the privacy policy in as many places as you can. Do you actually need to have it as a pinned post? No, I personally don't think so at the moment. I think the point about the German case is that, at that time, and we're going back 7 years, neither the Facebook, which is the main point of it, I think neither Facebook nor the Facebook fan page administrator had any kind of privacy notice, and they weren't being transparent and telling people what they were doing with their data. And I think from, it doesn't specifically say, but I think it was that point when, what were those? I want to say the word gate. There's a gate in there somewhere. Fan gate, something gate pages. I don't know. But anyway, things happened a little bit differently 7 years ago on Facebook. So now, obviously, Facebook are, if they're not already GDPR compliant, certainly working towards it. So I think certainly that, people, when people are signing up for Facebook now, they are being directed to the privacy policy. Obviously, with GDPR coming into force, we had all those pop-ups from Facebook advising of their privacy policy and how we can change privacy settings. A fan gate, yes, thank you. So I think that, yes, if you're a cautious type of person, stick your privacy policy in as many places as you can. Okay, will I be doing it? No. Okay, that's my thoughts on that. Right, Sharon says, can you tell me if we need to unsubscribe or delete the ones who didn't opt back in? Which one is the GDPR compliant way? Yeah, so what you need to think about is firstly, there's two issues here. One is you've got your marketing list, and then the other issue is that you're holding data full stop. Now remember that just storing data is processing, and you need to have a lawful ground of processing. So if you have a lawful ground for holding that data, and that might be, for example, to put a suppression list in place, so that you don't, if information somehow comes to you another way, or if there's a fault with the unsubscribe or whatever, then you'd need to keep that to actually work out that they've unsubscribed. Then you can keep a suppression list. Yeah. So yeah, the usual practice is to keep those people on a suppression list so that you're not mailing them. Is the usual practice. And if you search in the group for suppression list, you'll see that there's been a few threads about that. Robert says Schedule 1. Yep, I know it's Schedule 1. So if you go and have a look in the current pack and see whether that helps you or not, then let me know about that. Okay, and am I out of questions already? Oh, my word, it will be short. Okay. All right. Well, unless I'll keep talking for 2 minutes to see if there's any further questions, but if not, then that's great news. That means I can get away to my daughter's sports day quicker than I thought. But Ginny, did that solve your question? If you want to pop a little yes or no in the box there. And who else asked a question? Robert, if you let me know if that helped you at all, or whether you still need more on that. Jeanette, let me know if that helped you. Sharon, let me know. And then once I know that we've solved all your problems, if there's nobody else asking questions, then we can all go and enjoy our sunny afternoon. Emma says go and have fun at the sports day. Yeah, fun and sports day. I find them very stressful, actually. My daughter, she's only 5, and this is her she had one last year actually, so her second sports day, and she was doing. They had the flat race, and she was doing really well. She was coming a very close second to a boy, one boy who was ahead of her, and she slowed down completely so that she could cross the line with her friend, which half of me finds sweet, and half of me, when I was yelling at her to keep running and power on through. I can't lose my competitive side, even though they're only 5, even though it's only a sports day. I just can't keep a control of my competitive side. So I always find it a little bit stressful. I'm always the one that's shouting the most. Hello, Roman. Nice to see you. Have you got a question? We're wrapping up. I think we might have answered everybody's questions. So unless you've got a very quick question, I'm going to close this down. Ginny, anyone else who asked a question, let me know if that has solved your question. If not, we can talk about it more. Oh, hang on, I've lost all my questions. Swipe left. There we are. Right. Okay, so Robert says, for example, personal data types list customer data as I thought this was a category of data. Subject matter of processing also says customer data as an example. Okay, hang on, let me grab my thing. I might have a version without the examples in though. Yeah, my version that I printed out doesn't have the examples in. Personal data types, personal data categories, personal data types. Do you mean data subject types, or did I change that? Okay, let me go back to Robert's initial question. We're not sure how to fill this in. Okay, so I think I've got an old copy here, which isn't very helpful because I think I did just, I might have changed data subject types to something else. But the subject matter of the processing, well, really, what is, there's no magic to this. What is the subject matter of the processing? What is the processing for? So if you are, let me think of an example here. Give me an example, Robert, of who is, I don't know if you're the processor or you're using a processor, but give me an example and I'll walk you through that. In the meantime, I shall answer Paul's question. What's a natural person? Really, Paul, it's a living individual. Okay, so it means not a corporate entity. So that's it. And we'll just wait for Robert to give me an example and then we can walk through that. Oh, and we've got another question from Joseph in the meantime. The legitimate interest form, I presume we need to fill this in. Sorry, just got a call there. I presume we need to fill this in due to the privacy policy relying on legitimate interest for most things. Is this correct? Also, would there be any way you could include some samples of filled in legitimate interest forms? Yeah, I think I said I might do that, but I'm a little bit reluctant to do it because that's the point really, that you have to, if there is an investigation, you have to have shown the ICO that you have really thought about it in the context of your own business. It's quite straightforward if you follow, just answer the questions, and there's no magic to the terminology that you use. It's just really a thought process, and that you can show the relevant authorities that you've thought about it. So even if it's a one-liner or 2 words, that's absolutely fine. Don't think that there is any magic to it. There's no legal wording or anything like that for it. Just answer it honestly and reasonably, and that will be absolutely fine. Right, Robert says, we're processing leads on our client's behalf as a marketing agency. We process the data to give the lead to our client and to do email marketing. Okay, all right. So then the subject matter of the processing is I would say it is processing prospect data in order to pass on the leads to your clients in order to fulfill the agreement between us. So, I mean, you don't need to write that down word for word. As I say, there's no magic to this wording. Just reflect that's what the subject matter of the processing is really what it's all about. What is the essence of the processing? The duration of the processing, you typically put in the term of the service agreement. Obviously, if that's ongoing, then you don't need an end date. If it's a project based and it's for 6 months, then you'd put in the, 6 months, or, just the duration according to the service agreement. The nature and purpose of the processing, you will be collecting leads from wherever it is, and you will be storing that data and in order to storing and transmitting that data to your clients in order to pass on those leads. The data subject types are prospects, or rather individuals that are potentially prospects of your clients, and the personal data categories, whatever that is. Actually, I think I might have to, if I change that on your version, Robert, I think that might be the one that I've just tweaked. Okay, but as you can tell, there's no magic to what I think people are getting unnecessarily hung up on what goes in this schedule. Really, it's just a shorthand. It's a snapshot so that people can look at it and say, oh, so that's what the processing is all about. Okay, so really, it's almost sort of summarising what if you're processing under a service agreement, it's really summarising what that processing is all about under that service agreement. Okay. So Robert, just tell me, what's the last category that you've got on Schedule 1? Is it still personal data categories, or has that changed? I haven't got the most up-to-date version with me. But I tell you what, the now, does it say in here? Yeah, I think this directly comes from the provisions in... Yeah. So this is really taken from Article 28, and it says that it sets out the subject matter and duration of the processing, the nature and purpose of the processing, the type of personal data, and the categories of data subjects. So that's really what's driving that schedule. So the categories of data subjects, that would be the individuals who are prospects. Right, Robert's replied saying, it says data subject categories and personal data types. Yeah, so we just changed those two words around. So data subject categories. It's who are the categories of your data subjects, okay? So the categories would be individuals who are likely to be interested in X, or it could be corporates that are likely to be interested in X. And personal data types, what is the type of the personal data that is being processed? So is it names, email addresses, whatever it might be, okay? But yeah, don't get too hung up on the wording of that. It's there's no legal magic to it. It's just what is the reality of what you're actually doing. Okay. Mike says, apologies if this has been asked before, but is there a textbook way? Sorry, I forgot to put my phone on sleep mode. Is there a textbook response or form of words that would indicate on inquiry that we are or will be GDPR compliant? Is it sufficient to simply point them to our website, privacy and cookie notice on the website? Yes. So what you can do, are you a processor, Mike? Is that a data controller is asking if you're GDPR compliant as a processor or as a controller? Because I think if you're a processor, if you look at what people like MailChimp and You're both. Okay, so for the processor side, look at what MailChimp and Aweber have done. Look, they've got a page on their website that talks about how they are GDPR compliant. If you look in my pack, there is the checklist for processors. So if you went through that and had a web page that talks about how you fulfill each of those obligations, then that would be, I think, very valuable for your clients to understand that. And as a controller, then yes, I think, I don't think any controllers are going to go around advertising the fact that they're 100% GDPR compliant because, frankly, often we're not. So yeah, I think the fact that as a controller, point them to your privacy policy and your cookie notice. You could have, and in fact, I think it might be an additional document on my list of things to do, a data protection policy, which would be a statement that you can refer people to, which basically tells people how what systems and security you have in place in order to be GDPR compliant. So that's a document that will be coming out at some point. But that's a controller policy. Certainly for the processor side of it, Mike, if you look at the processor checklist in the pack and did a web page that talked about how you met all of those obligations, I think that would be really valuable for your customers to see that. Okay, any other questions before we call it a day? Let us see, I'll give it one more minute and then we'll sign off and we'll go and enjoy the sunshine. Okay, no more questions? No more questions, no more questions. Oh, someone snuck in there with a last minute question. Right, Cassandra says, I'm still redoing the sign up boxes on my website for people to receive a lead magnet, newsletter and offers from me. But what about T's and C's? Yeah, so terms and conditions, you should have a check of your terms and conditions to make sure that, just to check what they say about data protection. But typically what they'll say, the only things that they're likely to say are that you will, that both parties will act in compliance with data protection laws. Now, most legal contracts, if they've been drafted properly, will have a reference to laws that replace other laws. So the majority of people probably won't need to change their existing terms and conditions. Cassandra has said something else. Oh, I can't actually. I.e. privacy policy, not T's and C's. Do they need to tick it too? No. So you don't have to get people to agree to your privacy policy and to tick it, because that's like asking for consent to the whole of the processing. And remember that consent is just one lawful ground of processing. So the vast majority of processing that you do, hopefully, will not be reliant on consent. There'll be contractual reasons, there'll be legal reasons, there'll be legitimate interest. So no, you don't need to get people to agree and tick a box to say that they agree to your privacy notice. You just need to advise them of it at the point of collection of data. Okay, any other questions? Mike, you're very welcome. Thanks for coming on and asking the question. Right, any final questions? Final questions. Right, good. Okay, so I think that's it then for questions. Thanks all for joining me, and well done on continuing to work through the pack and put everything in place. And as always, if there are people who haven't yet heard of my group, then do spread the word, because I'm sure there's still many hundreds of thousands probably of small business owners who haven't even yet heard of GDPR. And I think, as we've seen from that the Facebook fan page administrator case, I think there's going to be, it's going to be an interesting 12 months to see how GDPR is interpreted and what comes of it. So I think that, it's certainly not the end of the discussion. It's, as the Information Commissioner's Office said, it's just the start. So if you do come across people in your networking meetings or wherever else and they've not yet heard of GDPR or they're not compliant with GDPR, then point them in the direction of the group. Thank you, Cassandra. Cassandra said, I've been spreading the word widely Excellent. Well, thanks for that, Cassandra, and for anyone else, point them our way, and we'll try and help them as best we can. All right, lovely people. I will see you. I'm going to do another Q&A on Friday, and then there's these ones for people who bought the pack on Mondays. So I will see you soon. Bye.